firm, Familia American Immigration Law Group. I have a stress-free approach to the American dream. I have been licensed for 30 years in the state of California. I practice immigration in all 50 states and around the world. And I have 4 kids. 3 are mine. One's a stepchild. And I am married to a Canadian national. And I grew up in Los Angeles. I went to UCLA for my undergraduate. And then I went to Hastings College of the Law, where our vice president went. And I am passionate about immigration law. My father and mother married in 1960. My mom was from England. She was an orphan, and she was undocumented. She came here on a tourist visa and overstayed her welcome. And my father was very poor, grew up in Los Angeles, Mexican. And he just studied really hard, and he became the student body president of Uni High, and then went to UCLA, and then went to UCLA Law School, served in the Army, and then he became a lawyer, and he was in private practice for 17 years, and then he became a Superior Court judge in the state of California in Los Angeles, and he was one of the founding members of the Mexican American Bar Association. I'm here to answer all the questions that you might have. I can't give you individual specific advice, but I can answer questions generally. And I would absolutely love to assist this group in understanding some of the harder issues. Hi, Maricel, how are you? Hi, Vanessa. Hi, Crystal. Hello, hello, hello. And I want to just be a person who you can bounce ideas off, thoughts, and I will try my best to answer legal issues as I see them based on the facts that are presented to me. But of course, when I do an intake, my team spends at least 30 or 40 minutes asking a lot of questions. Hello, hello. And with that, asking a lot of questions is one of the things that my mentor, Charles Wheeler, told me to do when I started immigration about 13 years ago. I really wanted to know how to be the best immigration attorney, because I had been an attorney for years before that, doing business litigation and all sorts of things. But he said, the number one thing you must do is really listen and ask a lot of questions, because oftentimes people come to me and they think they're going to do something, right? They're going to get their residency this way. And because of certain factors, I can advise them, hi, Elizabeth, that they can do it a different way. And oftentimes I have to tell them that they cannot get their residency, or they cannot get their citizenship, or they cannot apply for something. And that's I would prefer to do that than hurt someone down the road, right? This is a great question, Marisol. Hi, how long is parole in place taking? So that's different from advanced parole. Parole in place is it's actually an I-131 that's filed with the local USCIS office, and that's for military parole. And that's not the same as advanced parole. The question is how long it will take. It depends on which office your parole in place is filed in. I have seen it in local offices take 3 months. I've seen them take a year. So it all depends. The main issue is that you get it filed, and there is no filing fee when you're filing for parole in place for military family members, and that is filed directly with the local USCIS office. I hope that helps. Yes, you are so welcome. I love answering all these questions. Can special immigrant juvenile status do advanced parole? That is a really good question. So if you have, if you are a special immigrant visa holder, I do not believe that you can file for advanced parole. I don't think so. I'd have to double check that, but I don't think you do. I think once your visa is current, you can file for your green card adjustment of status. And then once you have adjustment of status, you're free, and your green card approved, you're free to, travel outside the United States. So I'd have to double check on my book. I don't think so. Oh, thank you, Angel. Thank you so much. 5 to 6 years for parole in place. I don't know. No, I've never seen. So parole in place generally does not take that long. No, I've never seen it in my practice taking more than a year. Yeah. So are you sure it's okay? Best way to handle a lawyer not giving me a copy of the application they file from me. So Maria, great question. So one of the things that is really important for people to understand that are working with an immigration attorney is that the immigration attorney owes a duty to you, the client, to provide you with your entire file. So if someone wants the file from me, I have to give it to them. Okay. I can't say you'll pay me. I can't say no, I can't. I have to give it to you in a timely manner. Maybe not that day, but I have to give it to you within short. So if you want your file, you just need to put it in writing. Put it in writing. Don't call. Just write an email or a letter. Make sure it's sent, and ask for a copy of the file. And if the lawyer doesn't give you a copy of the file after a certain period of time, I'd say a week or 2 or 3, I would file a claim with the state bar. So you can find out where a lawyer is licensed. Like I'm licensed in the state of California, and you can look up state of California and you can find my name, Gloria Cardenas, and you would be able to file a claim in the state of California against me. So that is something you should know as your right as the client, and my duty to you as the lawyer. Hopefully that helps. So I am licensed in. So one of the things about immigration is that if it's federal law, so if I can do federal immigration law, represent clients from all around the United States and the world, as long as I'm licensed in one state and only practice federal immigration law, which I do. I am only an immigration attorney. So I practice in all the states. Now I do have physical offices in San Jose, California, and in Salt Lake City, Utah, but I'm not restricted to taking clients specifically from my locations. And quite frankly, now everyone's hiring me and consulting with me on Zoom, WhatsApp, on the phone, and we just have a way to handle all of our clients in an orderly and systematic fashion. And you can get more information from me if you just go to familiaamerica.com. I'm also immigration_queen on social media. And my in my bio is my phone number and my addresses. You are so welcome, Karen. You're so, wow, that's a cute picture. Vanessa, great question. Can a DACA recipient travel with advanced parole and a deportation order? Yes. So a deportation order, let me just go back and explain the case. It's a case which has a funny name called Arabelli Urabelli. And in that case, the question was, is leaving the United States an actual departure, a legal departure? Of course, you're going to physically leave, right? Is it a legal departure such that it effectuates the removal order? Like, in other words, does it mean that you have been removed or that you have left the United States? And it doesn't. So it doesn't trigger the removal of you. Okay, so you go out and come back in on advanced parole. You're brought back in the same position. You still have the removal order, right? You still have the removal order, but you can travel on advanced parole and return to the United States on advanced parole, even though you have a removal order. Now, as you know, most people that have advanced parole, they go into, you put into secondary inspection, and the officer will see that you have a removal order. But the officers are trained to know that you can return to the United States on advanced parole whether you have a removal order or not. I like to have that information for my clients, so I always do a freedom of information request for all my clients. So I send it to every 4 agencies, which is the USCIS, OBIUM, which is a fingerprint FOIA, because you could give a wrong name or a different name, or the government could have it wrong. USCIS and EOIR. EOIR stands for the Immigration Court. So I always send it to the 4 agencies. Now, if someone has filed for a visa and been denied or ever filed for a visa, I send it to the Department of State. So sometimes I send it to 5 places. And I do that because eventually my client will likely want to get their green cards. And that way I will know what their whole record is. Plus, oftentimes I've seen where my clients didn't know they were removed when they were like 5 years old. And it's good for them to know that, so that when they go out on advanced parole and they get put into secondary inspection, they don't flip out when the officer says, "Did you know you had a removal order?" And you wouldn't want to learn then. So it's always good to do that. Hopefully they answered your question. Hi, Marcel, can an attorney fire you without notice and leave your case open? So leave your case open. I assume you mean that, let's say you hire the lawyer to file advanced parole, and then they file it, and then they fire you. Can they do that? Yes, they can do that, as long as your rights are protected. Like, they cannot do that and harm you legally. And if they would have to withdraw from the application. So let's say you hired me, I did your advanced parole, and then somehow I fired you because you were mean to me and abusive, and I just didn't want to deal with you anymore, which is not usually the case, because people are usually nice to me because I'm nice to them. Then I would have to make sure that USCIS knows that your current address, and I'd have to give you a copy of the file. So yes, to answer your question in a long-winded fashion, they can terminate your representation. Oh, Karen, if I do advanced parole to get a lawful entry and then my sister petitions for me, would it still take a long time for adjustment of status? Yes. So you're still, even though you come back in, 2 things, even though you come in on advanced parole, it doesn't speed up the visa. And that F4 category for brothers and sisters of U.S. citizens is a long visa wait category. The second issue, though, is whether you can actually adjust status. And that meaning, can you get your green card in the United States? And most of the time, unless you're in lawful status the entire time, all the way up until the green card interview, you cannot adjust status under 245A. You would have to consular process. Now, that's generally speaking. And again, your visa might not be current for 15 more years. So we got to look at the law when that happens, right? It will not speed up the visa. Oh, okay. What would be the best way for someone who was voluntarily removed from the United States to get granted a visa? He has already served his 10-year penalty and works for a U.S.-based company with a location in Mexico. That's a good question. So if the person was voluntarily removed from the United States or got voluntary departure and has served and had the 10-year bar, I think is what you're talking about, has already done the 10-year bar, that 10-year bar would not prevent him from getting his visa. But your other question, because the person's already done the time. The more interesting question is U.S.-based company with the location in Mexico. So if that person might be eligible for a TN visa based or an L1 intercompany transfer visa. So a TN visa is for people that are from Mexico and Canada that have a certain level of degree. And thank you so much. And or an intercompany transfer is something where somebody is working for a company that is actually based in the United States. So this might not totally apply to your friend. The company is based in the United States or their subsidiary is in the United States and they're working for that company abroad in Mexico. In that situation, this company can request an intercompany transfer. It's called an L1. Yeah. Hopefully I'm answering those questions. Can you travel with advanced parole? Hi, Sandy. Can you travel with advanced parole under DACA with a U visa case? Good question. So if you have a U visa pending, generally speaking, you cannot depart the United States and re-enter. You can. It's a really complicated, but your more important question is: can you leave on advanced parole with DACA and not jeopardize your U visa case? And the answer is yes, because remember, going back to the principle that it's not a departure. So I have no problem with my clients that have DACA leaving on advanced parole and coming back, even if they have a U visa pending. Hopefully that answers your question. And yes, okay. I love that picture, Zoma. That's so pretty. For U.S. DACA recipients who unfortunately cannot do an adjustment of status, is there any hope to see if we can apply for residency? That's very specific. And those people that cannot adjust status in the United States, that's what AOS is, can oftentimes consular process. So I would need to have a very detailed consultation with you, and I charge $100 for my consultations. It's fully refundable after the consultation if we decide that we don't want to work together. So it's like a tank of gas. 30 years of experience. So some people can, right? So I have a lot of people that consult with me and they cannot adjust status in the United States, but they can consular process, and they can do that. And depending on their grounds of inadmissibility and all that, it could be for a very short period of time outside the United States. Yes. So there is hope. Hi, Cece. When you process a FOIA and have a record, what happens? So nothing triggers. My first question people always ask me is, if I do the immigration background check, a FOIA, is immigration going to know and come after me? The answer is no, because millions and millions of FOIA requests are sent. Think of how many people want their immigration record inside the United States and outside the United States. When we file the FOIA to the different agencies, we get a receipt, and then we wait for the response. And when we get the response, what I do is I wait for all the responses and I analyze them. So I read through every page, and then I meet with my client and I say, okay, here's your entire immigration record that the US government has on you. So it's really good to do. There is no filing fee to do a FOIA request, and I don't charge that much to do them. And if you hire me, I always do a FOIA request. It's kind of included just because I just want to be sure, you know. Hi, Laura. What can we do when CBP officers don't want to give us our multiple entries advanced parole document? Yeah, I'm hearing about this quite a lot. Like, some CBP officers get angry, and they don't want to abide by what the USCIS has granted you. In that situation, I try to tell my client, well, first of all, I've never had that situation for my clients, but if the CBP officer doesn't want to give you it, I would respectfully ask to speak to a supervisor. And then if they don't want to do that, then you could, when you get back to the U.S., request, let's see what you could do. You could do a FOIA, and then you could get the advanced parole document that was issued to you, which you don't have. And that would be to the USCIS. Francie. Okay, I applied for first-time DACA application, but they froze DACA, so I don't have DACA. Now, is there a chance my boyfriend's soon husband, who is a U.S. citizen can help me. I came here illegally with no visa. Will that affect me? First of all, I'm sorry that, you know, they froze DACA, and we're going to be, you know, following the litigation carefully. But if you came into the United States, or if somebody comes to the United States one time unlawfully, EWI, entered without inspection, and they're married to a U.S. citizen, they are eligible to file for a 601A waiver, is for unlawful presence, because it's likely that when you leave the United States to consular process, you're going to trigger their 10-year bar. But you can file a waiver in the United States and get it approved before you leave to go to consular process, so that you're only in, let's say, Mexico or El Salvador, or, you know, France, or wherever you're from, for more like a week or two, to do the medical, the fingerprints, the biometrics, and the interview. So yes, if you're married to a U.S. citizen, you would start with an I-130 petition and an immigration background check. And then after that, it would be a 601A waiver, which is a provisional waiver for unlawful presence. And then when that's approved, you'd move on to consular processing, which is filing the DS-260 and then waiting for an interview in the consulate or embassy outside the United States. When you get that appointment letter, that's when you have to, you know, prepare to leave, and then you leave and you do all those things, and you likely will come back with your visa. Okay. If I'm a derivative beneficiary grandfathered under 245I, I have an undocumented spouse and plan to adjust via EB3. Would they be considered after acquired and eligible for adjustment, even though I'm only a derivative beneficiary to the principal? Okay, that is a great question. You are a derivative beneficiary, so you cannot have an after acquired spouse. If you were the principal beneficiary, then you could have an after acquired spouse. Can you repeat the FOIAs you submitted? Yes. USCIS, CBP, EOIR, OBIM, and the Department of State FOIA, assuming the Department of State handles all visa applications. So if anyone ever applied for a visa or was denied a visa, I always do the Department of State FOIAs. So, and they go to different places. I'm actually going to be on my website in the coming weeks. I'm going to be offering a kit that someone can purchase for a very small fee that literally is a step-by-step on how to do your own FOIA. That is going to be coming. So hopefully everyone got that. Okay, Crystal, if I'm currently doing consular processing, can I switch and do advanced parole then AOS? Yes, you can. The thing that I was pausing about is, if the I-130 is already at the consulate, if you go and come back in on advanced parole, oftentimes it's just simpler when you file for adjustment of status to do the I-130 again with the entire green card application, because trying to get the I-130 transferred back to the USCIS so that you could adjust status based on that I-130 that's already been approved, oftentimes it's just a pain in the butt, and it causes, like, USCIS can request it from the consulate, but oftentimes it's very hard to get it back. And so what oftentimes I will do is, just, if we're going to switch to you going out on advanced parole and coming back and filing for adjustment, I might just file an I-130, I-45, I-765, I-864, and I-130A all together. So a new I-130, so that when the interview is held, or maybe you don't even have an interview, the officer has everything to adjudicate at the same time, all in the file. Okay. Hopefully that answers your questions. Am I making any sense? Who knows? Javier, is information provided on original DACA applications forwarded to CBP? Can that information be used against you for adjustment status for multiple entries? Okay. Everybody has an A file. And whatever you say in an application can be available to any officer, whether it's CBP, whether it's a consular officer, whether it's a USCIS officer. And this happens quite a bit when somebody files for DACA and they say in their declaration that they, were brought to the U.S. by their mother. So that's bad for your mother, because that's essentially, it's a hard thing because it could be alien smuggling. But then I went and then I came back in and I had a brief, casual, innocent departure. And then you want to file for adjustment of status, but because you've disclosed your record, then possibly you've disclosed that you have what is called the permanent bar, which would not allow you to adjust status in most cases. Then yes, it could be used against you. And again, in these situations, when I say to my clients or potential clients, okay, do you have a copy of your entire DACA application? And they go, no, I don't have it. I didn't make a copy, or I can't get it from the lawyer. I'll do the FOIA, because what I want to know, and I want to read from my own little eyes what you said on that application. Okay. Because it's a waste of money and time if you have the permanent bar. Okay. Can you please let us know how you get an appointment with you for a consultation and where you're located? Thank you. Okay, so I am located in Salt Lake City in San Jose, California, but I have virtual consultations and I am licensed to practice law in all 50 states. So you can go onto social media and you can go into the link tree and schedule a consultation through Square, or you can call my office at 801. I don't even know my phone number, 801-656-9605. or 408-418-6621. 801-656-9605 or 408-418-6621. You are so welcome. And you can Google me, and my company is Familia America. Everyone should know that's American Family or Family America. And you'll find all the information. Or you can Google my name, Gloria Cardenas. You should be able to find that. You are welcome, Crystal. Okay, Christian, my stepson has joined the military, but he is still 18. Can my husband petition a work permit until he waits for his son to be 21? Yes. Okay. So this is what is really cool about parole in place. When somebody's son or daughter is a U.S. citizen and they can join the military when they're 18. At the time they join the military, they can file for parole in place, which is essentially like advanced parole, but you never even leave. You're literally paroled in the place where you're at. And if you get approved for parole in place, you can then apply for a work permit. And then when the child turns 21, that child can then file for residency for you. And you can renew the parole in place each year. Now, the regulations say that you had to have an I-130 pending in order to renew the parole in place. But what we do is we just have the military son or daughter write a letter saying, when I am not 21, but when I am 21, I will file an I-130 petition for my mom or dad, whoever they're petitioning for. And that usually is sufficient to get the renewal when the child is 19 and 20. So that, because you have to do the parole in place every year, which is really a pain in the butt, but it does give you a work permit. And then it also protects you from being removed from the United States, which essentially what DACA is deferred action for removal, as well as parole in place is deferred action for removal. What is going to happen to DACA? So right now, as we know, Judge Hannon has been ordered by the Court of Appeal to consider the DACA, but he's also been ordered to consider the regulation that has now been published by this administration. He is going to have to consider whether the regulation that did comply with the Administrative Procedures Act is constitutional. He can't just take up Obama's policy memo. And that is a good sign for DACA being approved for initial consultations, initial filings. And the reason why is because the main argument of why DACA was considered to be unconstitutional is that President Obama didn't comply with the APA. And so now that the Biden administration has complied with the APA, and the Fifth Circuit has directed specifically Judge Hannon to address this issue, that there's a good chance that we could prevail in DACA. Now, if we don't, then the administration will immediately appeal the decision back to the Court of Appeal and then ultimately to the Supreme Court. Oh, thank you so much. Yes, you can go on to that. Immigration_Queen. I have a TikTok, a new Facebook page, and I have an Instagram, and it's all under Immigration Queen as far as those social media are concerned. And that's my new logo. Okay. In my FOIA showed an entry, but I was in the US that time. Might it be bio data from a public benefit? If so, will? I don't understand your question. Will it affect adjustment of status? Will you put that question again? Because I'm not totally understanding that, and I don't want to say something wrong. Liz, how long does it take to get an I-130 to be approved? It depends on who files the I-130 for you. Assuming it's your cute husband there, or he's filing for you or you're filing for him, and one is a U.S. citizen spouse. It's generally taking, right now on the USCIS website, different service centers are adjudicating that, and I think it's taking like 10 months, but it can go faster, a little faster. Now, if it's someone else applying that's not an immediate relative, that's in a visa preference category, let's say a brother, U.S. citizen brother applying for a brother or sister who's undocumented, that could take, a couple years. So hopefully that answers your question. My uncle, a U.S. citizen, petitioned my mother and my family back in March 2001. Can I, as a DACA beneficiary, apply for the I-245? So, Adrian, that's a great question. Whether you're grandfathered under 245I, which would allow you to pay a $1,000 fine and adjust status in the United States, is a legal issue. And if your uncle applied for your mother and you were on Earth at that time, whether you're even designated or written in the I-130 petition, you would be grandfathered under 245I. So let's just say hypothetically you married a U.S. citizen. Then you would likely, assuming you don't have any other grounds of inadmissibility like the permanent bar, you would likely be able to file for adjustment of status in the United States under 245I, paying the $1,000 penalty on top of the other government filing fees. Is there any risk if I travel with TPS and deportation order? Very little risk, because again, a departure. So you're not going to be traveling on TPS. You're going to travel on advanced parole based on TPS. Again, it's not a departure, so you're not triggering the removal order. But again, you are so welcome, Liz. You are so well. Oh, Fancy Flower. That's a cool name. Do you know how long after the I-130 and fingerprints it is taken for a sibling to get their green card? So a green card for a sibling of a U.S. citizen, the I-130, in most cases, it takes a long, long time. If you're from Mexico, I think it's like a 19 or 20-year wait for the I-130 to be current because you're in a visa wait category, and that would be F4. So it depends. What happens after when an individual gets approved with humanitarian parole before the 10-year bar is over? What would be the next step to follow if you are married to a U.S. citizen? I have heard about prosecutorial discretion, but have no idea what they're talking about. Okay, so to answer this question, because there's like a lot going on there. Prosecutorial discretion is if you're in removal proceedings. And under the Biden administration, if you are in removal proceedings, you or your lawyer can ask for prosecutorial discretion to terminate your proceedings or administratively close your proceedings. So hopefully that answers part of the question. It doesn't answer it all, though. In my FOIA, I showed that I had an entry in 2005, but I was in the US. It seemed to me that it was when I requested for benefits, money from the government. I don't know if that affects me to do my adjustment of status. Well, so I would read the FOIA really carefully because on the FOIA results, oftentimes there's these entries, especially if like someone's been arrested. There's like an entry that appears like there's an apprehension when it's actually not. And then also I've seen on many FOIAs where someone where the government has like refreshed the FOIA results and it looks like there's an entry that's like from 2020, but actually it's just refreshing the record that was from like, 2001. Okay. So hopefully they answered your question. A juvenile came into USCIS custody and was released to an undocumented parent in the U.S. What avenues are there for status for juvenile? Okay. So if the person is a minor and they're under 18, so this is going to be a long-winded response. So many children from Central America, South America, Mexico entered the United States and they were well under 18. And one of their parent is in the United States that left, let's say, Mexico years and years ago, or Central America years and years ago. And the mom stays behind. But the mom's like, hey, you need to get to the United States. There are lawyers there that can terminate the rights of both parents or can terminate the rights of one parent. And that would be likely the parent that is in the United States because that parent, based on abuse, neglect, or abandonment. Now, obviously, you're thinking, well, why? No, my parent loves me. But legally, it could be considered abuse, neglect, or abandonment. And if the rights are terminated, even one of the parents' rights, you might be eligible to file for a special juvenile visa. You are so welcome. Yes, I take cases from all 50 states and beyond, all around the world. So it's not, you don't even have to be in the United States to hire me. How long for a petition for a U.S. citizen for a sibling if the birth country is Argentina? Thank you. All you do is go to the visa bulletin, Department of State, and type in visa bulletin, and you should be able to find that. Oops. I can tell you right now. So that is the F4 category. And for the for category, if for Argentina, which is in the left-hand column, they're processing I-130s with the priority date of before March 22nd, 2007. You can look at that, right? If you Google Visa Bulletin December 2022, you're going to find the Visa Bulletin, and then they'll tell you which category, because it's all written there, F1, F2, F3, F4, and then you just look at the country. And Argentina is in the main lump of countries. The other countries are separated, are Mexico, the Philippines, China. Hopefully that helps. Okay, Sandy, does a person that was caught at the border with a U.S. citizen documentation have any way of qualifying for a waiver and or ever legalizing their status? So false claim to U.S. citizenship is, if it happened after 1996, there isn't a pardon for it. But there used to be a pardon for it. However, many applications, you can have a false claim to U.S. citizenship and still get residency. Yes. Okay. Like if you're put into removal proceedings and you want to file for relief and you're undocumented and you file a 42B cancellation or removal, which is to get your green card through the immigration court, you can actually have a false claim to U.S. citizenship and still get residency through the judge. But generally speaking, it is a very harsh penalty for which there's not a waiver. I have DACA with a parole, but I have 2 illegal entries and my lawyer still wants me to file. So, yeah. So it doesn't, so leaving on advance parole and coming back in doesn't wipe away anything, and it also doesn't trigger anything. Does that make any sense? Think of it as just you're going and coming back, but you're like a ghost, legally speaking. And it's great to do, because, you never know if the law is going to change. Okay, Brenda, my husband has been in the U.S. since he was 6 months old. We have been together since 2015 and now married for 6 months. Do we have to be married for a period of time for me to submit an application for him? How long will it take the process for him to get his green card? Also, will he have to exit U.S. and go to Mexico? To answer your first question, you can apply for, once you're married, you can apply the next day if you have everything ready. It doesn't mean that you have to be married for a certain period of time. As long as you're married in good faith and have some documents. Oftentimes someone wants to wait a few weeks or months or something so they can get a lot of commingled documents like joint bank accounts, joint utility bills, rental agreements, and all that kind of stuff that for the U.S. government they love. To answer your question of how long it will take to get your husband's residency, that is a question that I cannot answer because I don't know whether he's going to adjust status in the United States or he's going to consular process. And I don't know whether he has DACA and if he got it when he was under 18. So there's many factors, but that's what I do when I meet with people is I have a detailed conversation with them. And I try and find out, first of all, if they're maybe a derivative beneficiary or a beneficiary under 245I, if they're a grandfather, because that's amazing. And also then I have to figure out if they had DACA when they were under 18 and have maintained DACA, because if they have to consular process, it's very likely that they don't need the 601A waiver and they can go from I-130 to consular processing, which would eliminate the whole backlog and the processing times for the 601A waiver, which is taking 32 months right now. So hopefully that answers your question. What happens if a son is in the military, wants to petition their parent, however, parent had multiple entries to the U.S.? Will the multiple entries affect the case? Great question, Jessica. So parole in place, you can get parole in place even though you have the permanent bar and could not thereafter adjust status, because parole in place could be just enough. So to answer your question, it can affect some offices will look at to see if the person has the permanent bar, let's say, that would preclude them from getting adjustment. And then in their discretion, they could deny parole in place. But I've had clients that have had the permanent bar and they've gotten parole in place. So it's not by regulation. It is not a reason to deny someone parole in place, but it is also a discretionary factor. After priority for special immigrant visa, juvenile visa is present. After priority date, so if your special juvenile visa priority date is current, is adjustment of status process the same as DACA? No. So you're going to be filing for adjustment of status. So you're going to be filing specific forms, and they're different from those that are filed for DACA. And the cases that I've done, generally the adjustment of status or green card is approved just on the paper filings. Can you please repeat the false claim on U.S. citizenship, please? Okay. There are many applications where you can have false claim to U.S. citizenship and still get your residency or benefit. But generally speaking, a false claim to U.S. citizenship that occurred after 1996, there is no waiver for. If it happened before 1996, there is. Man, you guys are rifling the questions at me. I'm going to definitely have a glass of wine when I get home. My husband's watching, so sweetie, you know what I need. Rosé. What is the estimated processing time for a U.S. citizen child to petition a parent with adjustment of status? So adjustment of status is, so if you're filing for adjustment of status, you're going to be looking at the USCIS case processing times where for the location where you're going to be having the interview. So let's say you file in San Jose, you're going to go on to USCIS, do the drop down for case processing times, put I-45, choose San Jose, California, because I'm sure that's where your mom is. And then you're going to see the exact processing times. I will say right now in the United States, it's taking around 14 months to 16 months to get an interview for adjustment of status in the United States across the board. Some offices are taking longer, though. Hi, Anna. How long does a FOIA request typically take to come back? So they go to all these different agencies, and some of them come back quickly within a few weeks. Some take months. Mm-hmm. Oh, Anahit, thank you so much. That's so nice. I truly appreciate it. Thank you. I just have a few more minutes, and I'm going to take just a few more questions, maybe 2 questions, and I'm going to call it a day. But it's been fun. I love doing this. Can someone with a prior deportation and get advanced parole with DACA adjust status through marriage, or does the permanent bar for reentry prevent them? So if you have the permanent, so someone that has a prior deportation order can get advanced parole with DACA. Whether or not you can adjust status depends if you have the permanent bar. If you have the permanent bar, you cannot adjust status in the United States, nor can you consular process until you're outside the United States for 10 years. The permanent bar is one of those things that is a very complex area of immigration law. And it's something that I flag every single time I take in a new client, because I have to literally look at their entire immigration record. And then there's 2 types of permanent bars. And I have to go, okay, do they have the permanent bar because of the removal order? Yes or no? Then I have to go, do they have the permanent bar because they had unlawful presence in the aggregate after April 1, 1997, departed and entered the United States without inspection or attempted to enter the United States without inspection. So there's a lot that goes into it. And what I would say is that if you could do the advanced parole with DACA, even though you have the removal order, but if you have the permanent bar, because you have the removal order, you cannot adjust status. Vanessa, my gosh.
Thank you. Wow, we had a lot of questions for you. They had a lot of questions for you.
Oh my. It's like my, but it was fun. I love it.
We love it. Thank you so much for coming up here and answering some of the questions. You know, we love a good lawyer, you know, that's on our side and is able to help us out, you know. So we really appreciate you coming on tonight.
I appreciate the opportunity. It's fun. You know, I'm not doing this to get clients, you know, because I'm here. I had a radio show for 7 years. And then at the pandemic, I just decided not to do the radio show and I started getting on social media. Yeah. And I just I used to pay for the radio show and I did it for 7 years. And I just to impart my knowledge and to people because that were not aware of immigration. And oftentimes I had people that were US citizens that, you know, weren't apply for anyone. They just like listen to me. They're like, oh my gosh, our system is so broken. And it helps them when they vote to vote for someone who's going to be pro immigration reform. Because even today, right now, in answering a lot of these questions, there's a lot of very heavy legal issues that are complex and they're not for the babies. They're not for the baby lawyers. They're for the experienced lawyers.
Yes. And this is her Facebook guide, Gloria Cardenas, right here. Just click on it.
Yes.
I'll try to tag you today in some of these questions. You can also go back from your Facebook and answer some of the questions so they can see your Facebook and, you know, they can just send you a message to her.
I will likely do that tomorrow. Tomorrow, the next day. I have 7 consultations tomorrow. So it could be the next day, Saturday.
Right, so I'm going to close the live here and thank you so much.
Thank you so much. Have a good night, you guys.